Thank you again, everyone who's joined us live, as well as those of you that might be listening to us at a later date and time. Our August webinar is going to be focused on state plan states. Title, as you can see, enough on FedOSHA. I know I've had my fill of FedOSHA lately. We've been busy, but there are lots of things going on in the states, as I'm sure many of you are aware. Those of you that have operations throughout other parts of the country and in state plan states, we've handled matters in every state plan, and that includes Hawaii and Alaska. So I think we're in a good position to update everybody as to some of the important developments in various states across the country. We're going to share some interesting practice pointers, things that you might not know, regulations in states that go above and beyond what FedOSHA requires, different record keeping requirements, different reporting requirements, things that you'll definitely want to make sure that you all are handling. So with that, we're going to jump right into it. I am very excited. We are joined by a fantastic group of state plan workplace safety and health gurus. I don't pretend to be one of those since I'm based in Illinois. So again, my name is Aaron Gaub. One of the firm's co-managing partners, sit in Chicago, where I lead the firm's Midwest OSHA practice. But because Illinois is sandwiched in between a number of state plan states, I have handled a number of matters in Iowa with Iowa OSHA, Indiana OSHA, up in Minnesota. And so in addition to a number of other state plan states that I'm going to talk about, one of which I'm going to talk about down in Tennessee in a little bit. So with that, other than I think many of you have joined prior webinars, you've seen or heard my bio, so I'm not going to belabor it. I've been doing this for close to 30 years, all on the management side, and I handle all aspects of OSHA defense, from inspections to consultant engagements to contested litigation. We're actually getting ready to try a case in a couple of weeks, possibly with OSHA out east, as well as appeals and all the other fun stuff. So with that, I will turn it over to one of our newest members of the firm, who I'm very excited to introduce, Rachel Kahn.
Thanks, Aaron, and happy to be here with everyone this morning. I'm Rachel Kahn, and I'm one of the newer additions to Kahn Maciel Carey, and happy to be here. I chair the California practice and have been working with Cal OSHA for many years now, as well as in a lot of the state plan states and throughout the country as well. And I just came from a AmLaw 100 law firm where I was the national OSHA practice leader. So again, a lot of experience, not only on the West Coast, California, but Fed OSHA and throughout the country, like a lot of my colleagues here. Megan, I'll pass it over to you.
Thanks. Hi, everyone. I'm Megan Chicad. I am a partner in our San Francisco office. I practice in both our firm's labor and employment practice as well as our OSHA practice. And I am kept busy these days with all things Cal OSHA. So handling inspections and counseling clients on compliance matters and generally keeping up on everything that the agency is doing these days. And as well as helping out with other West Coast matters and kind of anything else that comes up out here on the West Coast. And with that, I will pass it to Valerie.
Thank you, Megan. Hi, I'm Valerie Butera. I'm also new to the firm. I'm in the firm's newly minted Detroit office. I have also been an OSHA attorney for about 20 years. I've worked primarily in private practice, doing both federal and state plan work. Being located in Michigan, of course, I do quite a lot of state plan work, both here and also in other states. I have worked both in private practice, like I said, and also was in-house counsel for one of the big three automakers for several years. So sort of seen a little bit of everything and feel like I've done a little bit of everything. And I'm very happy to be here.
Hi, I'm Victoria Voigt. I'm of counsel with the firm. I was lead counsel for the state of North Carolina for all things OSHA for a very long period of time. Have retired and I'm enjoying practicing with the firm. My specialty is North Carolina, but over time I've interacted with a lot of the state plan states. I've also interacted with Fed OSHA for a long time, sometimes as an adversary. But I look forward to telling you about all things North Carolina.
Thank you, Victoria. And as you can see, we've assembled quite a team. It's really exciting to watch the growth of our California practice with Megan ascending to partnership and Rachel joining us to add Valerie to our team in Michigan, and although he's not able to join us, Tony Castelletta, who spent close to 2 decades with Michigan OSHA, brings a similar perspective, that a very valuable perspective, just as Victoria does. So hopefully you all get a sense that you're going to hear from some really sophisticated and knowledgeable practitioners. We're going to start off talking about some key differences between Fed OSHA and state plan states. You know, obviously we're not going to be able to cover every single difference, every single nuance, but we want to focus, I think, primarily on areas and topics, things that you need to be particularly mindful about. You know, areas you may say, hey, you know, can you all at CMC help us figure this out? You know, what we need to do on this issue or this aspect in a certain state plan state or various states. Then we'll move on to taking a look at some of the specific state plans and some unique aspects of each state that we'll dive into in a little bit of detail. And then we'll end with our recommendations for best practices for those of you that have employees working in multiple states. So with that, I think I will turn it over, I believe, Megan, to you to get us started on the content.
Valerie is going to give kind of a high level overview of the major differences between Fed OSHA and the state plan states.
Thank you. So let's just jump right in and talk about some of the fundamental differences between federal OSHA and state plans. For one, federal OSHA only regulates private employers. The majority of state plans, on the other hand, are going to regulate both state and local government employers as well as private employers. A handful of state plans regulate only state and local government employers. That's the case for Maine, Massachusetts, New York, Illinois, New Jersey, Connecticut, and the U.S. Virgin Islands. Federal OSHA regulates private employers in those areas. Reporting requirements for workplace fatalities and serious injuries can vary quite a lot in state plan states. Some of the defined terms like inpatient hospitalization are defined differently than the way federal OSHA defines them. And those kinds of differences can make huge differences in your decision about whether something is or is not reportable. So you need to really pay attention to those nuances. Some states have unusual requirements too that you need to do that are above and beyond what we're used to handling when we have a federal OSHA report, such as securing the scene where the incident took place that's related to the injury that you're reporting. Federal OSHA inspectors are subject to fairly uniform training and other employment requirements. With state plans, it's a little bit different. They can do their own thing. They're supposed to be consistent or as effective as federal OSHA officers are, but you're dealing with different training, different kinds of expectations. So there can be a little bit more variation between inspections and between what different inspectors, the way that they interpret the standards of that state. So it can be a little bit tricky dealing with folks in the state plan inspections. Penalties assessed by federal OSHA are adjusted each year for inflation. State plans are supposed to follow suit, but in reality, a lot of them have not and are still assessing really much lower penalties, at least for now. Federal OSHA is pressuring state plans quite a bit to catch up. I'm here in Michigan, and this is one of the states that federal OSHA is really putting a lot of pressure on the state plan to switch to the same kind of penalty structure, which would be a dramatic increase. Another couple of really important overarching differences. Some state plans have more resources than federal OSHA and can complete more inspections. Cal OSHA is in the lead there. It conducts the most inspections annually, at least as of right now. And state plans have their own unique standards. Some of them have volumes of unique standards, including some things that federal OSHA wants to do, but hasn't been able to pull off yet. So there are states that have workplace violence standards, that have heat exposure standards in place, ergonomics, things of that nature. And with that, I'll hand it back over to Rachel.
Thank you, Valerie. As Valerie mentioned, there's several state plan states. There's 22 to be exact. And if you are a national employer and you have facilities in several states, you may be governed by federal, you may be governed by state, the state plans. And of course, you're going to want to know beforehand what regulations are going to apply to you. So with that, we'll get started on our tour of some of the bigger state plans. So I hope everyone is very impressed by that graphic of us in the car. I know that I personally am. So as we get started on this road trip, just a couple of things to keep in mind. Some of the major issues that vary state by state that you're going to want to know ahead of time are procedural quirks. Every state plan has its own way of contesting appeals, processing appeals, the way it goes through the appeals process. So you certainly want to be aware of that. Of course, unique regulations, as Valerie mentioned, workplace violence prevention regulations, as we have out here in California for our healthcare, and are developing in general industry, wildfire smoke, heat illness. We're seeing more and more unique regulations pop up. And of course, the West Coast typically leads the charge there. And particular enforcement priorities. You know, many state plans and FedOSHA do share similar enforcement priorities, but you know, depending on where they are in the country, those could differ. And it's always important to know what are the specific emphasis programs in your area. And with that, I will hand it over to Aaron to get us started.
Thank you, Rachel. And you make a good point as far as understanding the actual appeals process and who are you going to be dealing with. Each state does it a little bit differently. We handle quite a lot of matters in Indiana, and there is, as last I checked, there is one lawyer that handles all contested citations in Indiana. It's very genial and easy to work with. Not easy in that he rolls over, but just he's reasonable, he's fair, but he's incredibly busy, and so you just have to kind of expect it's going to take a while because he doesn't have a team of lawyers to review each contested citation. Indiana has, or I should say Minnesota has a larger team of lawyers, also pretty reasonable to deal with, or I should say fair in dealing with us. They don't engage in any what I would consider, you know, overly aggressive litigation tactics. They prosecute their cases vigorously, and they are effective advocates, but we get along with them. We can push cases forward in a productive manner. One of the things that's interesting, there are a number of, I should say, interesting aspects about practicing in Minnesota, or I should say operating a company in Minnesota. One of which, and I'll kind of jump around on this slide, is that there are both indoor and heat and cold requirements. So not only is there, obviously everybody right now, we're in the height of the summer, we've heard all about everything going on in the Southwest and how hot it's been in Phoenix and in Texas, and the law that was recently enacted in Texas that got OSHA fired up because there are employers that can't provide or not states, or should say cities, that can't require water breaks, rest breaks, etc. So Minnesota has an indoor heat rule, which looks at the 2-hour time weighted average. It cannot exceed 77 degrees for employees who are doing heavy work, 80 degrees if doing moderate work, or 86 degrees if doing light work. And that is for acclimatized workers, which is a very important consideration. I know when I look at employers' heat stress programs, acclimatization is something that OSHA is paying a lot of attention to. And while many employers that we work with are doing a really good job in the majority of those elements of a program, that is one area that is not quite as even. Certainly most of our clients are doing that, but not all. So if you have a heat stress program, definitely take a look at your acclimatization practices. The indoor cold stress issue is one that catches a lot of folks unaware, who might just have one location in Minnesota, or just that it's never come up. You might not think, well, Minnesota is a state where they worry about it being warm enough inside, since they're pretty hale and hardy people out there and are used to cold. But the requirement is that you need to maintain a minimum temperature of 65 degrees if employees are engaged in light to moderate work, or 60 degrees if heavy work. There is an exception to that for situations where you cannot maintain that temperature because of where it's, quote, prohibited by process. Typically that would be, obviously, if you're operating a food storage warehouse and you have to keep it below a certain temperature, you've got a blast freezer, obviously you can't keep it 60 degrees in there. But I have found that the agency itself to be rather inflexible on that view if it is something like a warehouse where dock doors are opening and closing. So it can be a particularly challenging consideration. There are also requirements to maintain what is called an AWAIR, which is an workplace accident and injury reduction program. So somewhat like the I2P2 requirement in California. It is the requirements to have one of these programs is based on your NAICS code. So if you are unsure of whether you fall within that, let us know. We can dig into that for you and let you know which NAICS codes require adoption of such a plan. Relatedly, there's also a safety committee requirement. The statute requires that employers with 25 or fewer employers have a safety committee if they have either a lost workday case incident rate in the top 10% of all rates for employers in their industry, or a workers' comp premium classification rate in the top 25% of premium rates for all classes. So if you fit into either of those categories, you will need to have a safety committee. So those are, and there's also, as you can see from the slide, the Minnesota OSHA is still enforcing 1910-178 M12 with respect to lifting personnel, which is something that was deleted by Fed OSHA. So takeaway, pay attention to your temps, indoor temps, both high and low in Minnesota. Figure out whether you need to have one of these injury and accident reduction programs based on your NAICS code, and then take a look at your incident rates and your comp rates to determine if you need to maintain a safety committee. So with that, I will turn it over, I believe, to Valerie.
Thanks, Aaron. So let me introduce you to my state and all of its irregular stuff. There's some things that make Michigan OSHA or my OSHA matters unique and sort of an interesting thing to deal with. First, and perhaps most importantly, I harp on this a lot, is the fact that my OSHA considers all employee interviews private. And what I mean by that is historically in Michigan and most state plans and federal plans, employees could ask to have a union rep, they could ask to have managerial rep, they could be represented by counsel. in employee interviews with OSHA. But last October, OSHA instructed all of their inspectors that going forward, these interviews are going to be considered completely private. And what they mean by that is you can't have your union rep, you can't have your employer representative, you can't have an attorney. The only people who are allowed in the room are the person who is subject to the interview and the OSHA inspector. And of course, conveniently to OSHA personnel can also join. So people like trainer, people who are in training, OSHA retained interpreters, things of that nature, all can come in, can be there, but nobody else. And that's true even for supervisory employee interviews. Of course, what we're used to is because supervisory knowledge is imputed to the company can be there, the company's counsel can be there. And this is the case under Michigan law too. Michigan law also imputes supervisor knowledge to the employer, but OSHA is saying, we don't care about that. You can't have someone from the company in the interview. You can't have company counsel there. It's just OSHA and the employee. There is a way around this. You can get management and company counsel back into the room for supervisory interviews, but there's a procedure to it, and you need to, have someone that knows how to navigate that in order to make it happen. So, if you have facilities in Michigan, you might want to consider letting your folks know, if they don't already, that the first thing they should do if OSHA shows up at the door is alert counsel, so that you can be involved and have a chance to get the company back into supervisory interviews. The majority of the safety standards that are out there for state plans come from just 4 states, and Michigan is one of them. They have dozens of unique standards. And they're generally pretty demanding. They can be quite particular depending on the industry. So it pays to sort of familiarize yourself with what standards are out there and see if there's, some of these sort of unique, tricky things might apply to your facility. The appeals process is different too. The first appeal goes right back to OSHA and is usually just dismissed as a matter of course. Then you have a chance to file a second appeal. That one goes to the appeals division. And once it gets there, you have a pre-hearing conference with an appeals officer. And these are 2 different women who are both, just like Aaron was talking about with Indiana and Minnesota, lovely people to deal with. That being said, they're very challenging in terms of trying to actually get a settlement offer that is useful. So, you have to really keep pushing and really work with them to have an effective settlement conference. In your pre-hearing, I should say too, it runs like an informal conference. It's generally a telephone conference with you, the inspector, and the appeals officer, and you just go through and present your case, and they have 30 days to come back and make a settlement offer to you, which they usually take. And after that, you have 21 days to decide whether you accept their offer, or you can present counter offers and see where you can get. If that doesn't work, then the case is assigned to an ALJ. And an AAG, an Assistant Attorney General for Michigan, handles the case. OSHA being the AAG's client, the AAG only has so much wiggle room or flexibility. I've been told by several Michigan AAGs that they feel that OSHA is by far their toughest client. So once you get to that point, it can be very difficult to finally reach a settlement. That being said, it certainly can be done. It's just an uphill battle. You have to expect it's going to take a while. I find that more often with my OSHA cases than federal cases, you're having those settlements happen at the doors of the courthouse kind of thing, as opposed to with federal OSHA, you may get lucky and be able to work something out a little bit earlier in the process. And with that, I will hand it over to Victoria to share some pointers on North Carolina.
The information that I have on my slide is basically information that I got from General Counsel at North Carolina about the current state of things in North Carolina, but I will add to that based on my own personal experiences representing NC OSHA. North Carolina was one of those states that for a long time fought the feds on the penalty increases. But last fall, they went ahead with the adoption of the Consumer Price Index for automatic adjustments and penalty. They just gave up that fight. They are also now looking at the federal practice of criminal prosecutions and instance by instance citations for high gravity. North Carolina has a criminal willful statute. It has historically not used it because there are other criminal statutes out there that are stronger than what you can get under a criminal willful. And it can be counterproductive to go that way. You can get further under the civil penalties or the administrative penalties. North Carolina generally follows the feds with regard to standards, things you should know going into North Carolina. There's limited discovery in North Carolina, pretty much. The employers are limited to making a public records request through the state website, the state OSHA website, for a redacted copy of the file. And then beyond that, 10 days before the hearing, they can get an unredacted copy of the file. It is problematic to get related files. So if you have an accident and there are 3 employers or 4 employers on the site, you may get pushback if you say, I want all 5 or all 4 inspection reports instead of just mine. So it's something to be aware of. In North Carolina, you can do requests for admission as discovery, but if you want to do interrogatories or requests for productions or depositions, you have to say, Mother, may I, to the hearing examiner. So you have to actually file paperwork to request permission to conduct discovery. The hearing examiners in North Carolina are licensed attorneys in private practice who are on contract to the OSHA Review Commission. So that is also a little different. They are not state employees. They predominantly do virtual hearings in North Carolina. They started that during COVID, realized it was a lot more productive and a lot more effective. So they pretty much do virtual hearings 99% of the time. When you request a inspection file in North Carolina, you can expect for a long lag time to get that file. They're simply backlogged, and it's a first come, first serve, or need for, because you are in a situation where you're getting close to a pre-hearing conference or you're getting close to a hearing, and they will advance you in line. Other things to know of: North Carolina has its own special emphasis programs. I think there are 7 of them. You should be aware of that. North Carolina does general schedule inspections, as does everybody, but they also have a category of inspections based on their special emphasis programs. So long-term care facilities, for instance, can get their own selection process with regard to the equivalent of general schedule inspections. Private interviews. I found that discussion interesting. In North Carolina, the statute reads the same as the federal statute, but the state interprets their statute differently. Generally, employee interviews and management interviews are private unless the employee or the manager ask for legal representation. So it's got to be a specific, I would like to have an attorney present. And there may be a question and answer process for that to ensure that the attorney present represents the individual that is being interviewed. So if for instance, the employer's attorney wants to sit in on an employee interview, and the employee says, yes, I want him to sit in, there may be a question and answer session on that. Do you in fact represent this employee? Is it a conflict of interest for you to represent this employee and this employer at the same time? With regard to management, even if North Carolina can, under case law, establish employer knowledge through individuals that are not considered managers. That would be a foreman, a lead worker, or a competent person. In all three of those situations, they're not anybody that you would think of as a manager or a supervisor, but they have that responsibility, and therefore North Carolina can establish knowledge. Typically, if I'm dealing with, or when I was dealing with employers with regard to managers, I would require them to identify those individuals they considered to be managers. And at that point in time, I would say that I would not contact those people directly if they considered them managers and covered under their umbrella. Everybody else was fair game. So it's another thing to think about. With regard to settlement in North Carolina, North Carolina, first of all, has a review process for citations. Certain categories of citations receive a higher level of review up through and including review by an attorney before issuance. They have an internal guidance on what those are. Any citation that goes through that process prior to issuance goes through the same process for settlement purposes. So for instance, if it's a fatality and the supervisor wants to settle the case, the supervisor has to go up their chain of command to the head of compliance to get approval. So depending on the nature of the citations, the supervisor may or may not have authority to settle the case. The attorneys have no authority to settle the case except what the client grants them. So it is not uncommon for the attorney to say, supervisor, district supervisor, compliance head, what's my settlement authority? And work within that settlement authority until such time as you can't, and then you've got to go back and say, Mother, may I? You can give your opinion about whether or not it is an appropriate settlement. But at the end of the day, it is the client, and the client is OSHA. Another thing to think about in North Carolina is pre-hearing conferences. In North Carolina, we have those with regard to actual getting ready for hearing, but we also have a lot of pre-hearing conferences to try to get settlement jump-started. So if, and it can be started from either side. If the OSHA attorney is asking for a pre-hearing conference, well, it may be because they have a concern about whether or not OSHA is properly evaluating the case and what would constitute a reasonable settlement. And so in that instance, they may be asking for a settlement conference so that the two attorneys, a hearing examiner, and the clients can be closeted in a room and try to work this case out. So pre-hearing conferences can be very, very helpful in moving the two parties towards a reasonable settlement, because you do have to listen to each other's position. It's not surprising that having issued a citation based on information that they believed to be accurate, which may or may not be the case, that they are reluctant to move off of those citations. So sometimes it takes an educational process in order to help somebody move on to the next thing, so that we can come up with whether or not it's properly classified, whether or not the penalty is reasonable, whether or not the abatement is in fact feasible, whether or not the right citation was, right standard was cited. All of those things are issues that can be resolved in a pre-hearing conference. So it is a really helpful tool, I think, in North Carolina. And I think that's it for me. So next up is Tennessee. And I think that's Aaron.
Yep, it's me. Don't regularly get down to Tennessee, but handle a lot of Tennessee OSHA matters. And I'll keep my remarks relatively brief about Tennessee. I think the main takeaways, and it's I think consistent with a lot of the other state plans where I've handled cases. I find enforcement can be pretty aggressive, like Fed OSHA as well. I mean, a lot of it obviously depends on your compliance officer. As we all know, you get the occasional compliance officer who's more concerned about their 4:30 tea time than they are doing a comprehensive inspection. Not suggesting that there's anyone in Tennessee like that, but let's just say I've dealt with folks like that in other parts of the country. But by and large, the enforcement matters that I've handled down there, compliance officers have been relatively very thorough, pretty aggressive. I found during the informals, surprisingly less flexibility, less willingness to consider enhancements, less willingness to consider creative solutions. I think for those of you that have worked with us and had us handle informal conferences for you all, that one of our things that we really focus on is coming up with creative solutions, focusing on efforts to reduce the potential risk for a repeat citation. And we've got in with offers with proposals in Tennessee OSHA that I think in many instances would have helped resolve a Fed OSHA citation and found very little interest. Why that is, I don't know, but they seem to be, I think, consistent with what Victoria just said. When they have just issued a citation, they seem even less likely to give them up or make significant changes compared to some of the Fed OSHA area offices that I've worked with. On the flip side, the fines tend to be pretty low, at least for serious citations. Obviously, you don't want to repeat, and willfuls are going to be, I think, relatively significant there as well. But that is probably the major difference that I see in Tennessee compared to the feds. And again, it's not something that's unique to Tennessee. There are a number of state plans that approach it like that. A couple of key distinctions in terms of the regulatory framework in Tennessee, as you can see from the slide. The Tennessee's HAZCOM standard requires annual training for employees, HAZCOM training. There's also a placard requirement to be posted when you have non-containerized gases present in the workplace. There are some unique aspects to the Tennessee Sharps law. If you've got chemicals and you deal on the IH side with PELs, keep in mind that there are certain chemicals where Tennessee enforces a lower permissible exposure limit than the feds. Then you've got kind of one of these outliers where Tennessee has a state ban on smoking, and Tennessee OSHA actually enforces it. So keep that in mind if that's an issue in your workplace. And then last but not least, I've seen several questions that have come up regarding the safety committee requirement in Minnesota. So we'll get back to those of you that have questions about the scope of coverage. Tennessee has a safety committee requirement for employers that have work comp experience mod factor above a certain level. In our understanding, you will get a letter from Tennessee, the state of Tennessee, advising you of that that your rate is above the threshold and thus need to have a safety committee. So if you haven't gotten a letter, if you have concerns and you believe that your rating is above there, certainly let us know. We can look into it. But our understanding is that you would be given advance notice of that expectation. So that's a high level review of some of the issues that I've dealt with in Tennessee. And I will now turn it over, I believe, to not sure who's covering Utah.
This is Rachel, and I am gonna kick us off here out at the west as we move west for the last piece of this webinar. I'm going to start with Utah and Washington and then turn it over to Megan to bring it home with Oregon. And as I like to call Cal OSHA, everyone's favorite state plan. So to kick it off with Utah, and I'm just going to hit some high level things here because Oregon, Washington, and California are really the more aggressive state plans that we're going to want to spend a little bit more time covering with you today. But for those folks on the call that do have facilities in Utah, it is one of those states that does have unique reporting requirements. It covers things like disabling, serious, and significant injuries. So there are unique aspects there. So again, if you do have facilities in Utah, you're going to want to make sure that you understand the reporting requirements because they even differ a lot from a lot of the other West Coast state plans significantly. And we do also offer one quick plug for the reporting and recording masterclass that CMC offers that can help you through some of these more complicated issues. So for Utah, a couple of the other things that stand out, when a business achieves Safety and Health Achievement Recognition Program, they're SHARP, it is exempt from programmed inspections by Utah OSHA compliance. So that can certainly be a very significant tool for compliance and enforcement avoidance in Utah. Informal conferences can be conducted prior to the notice and contest being filed. So that is additional way to get potential enforcement resolved prior to having to go through the entire contest process. And a couple words about local emphasis programs. There's local emphasis programs right now going on in construction regarding amputation, silica, which is an emphasis for a lot of areas, and in the public sector. And we will move on to Washington. So the Washington state plan is also procedurally pretty different than the other West Coast state plans. And it can be a little bit of a frustrating process as an employer because the way that procedurally an appeal works, it sometimes feels like you're litigating your case twice. So it's a longer process. It can be a little bit more of an expensive process. So one thing to think about when you are appealing or contesting citations in Washington, the first step is to have a reassumption hearing with the Washington Labor and Industry Department. And it somewhat acts like an informal conference, but it's a little bit more formal than, let's say, you're going to have out in California with Cal OSHA. And if the reassumption hearing is unsuccessful, then you appeal it to the Board of Industrial Insurance Appeals. So again, it feels a lot of times like you're trying the case twice because the reassumption hearing can feel a little bit more of a formal process. Washington also has several unique standards. It has heat illness and wildfire smoke, which is not unique to the West Coast. That's similar to Oregon and California, although the standards are significantly different between the 3 states. So if you do have facilities in those 3 states, just know there's different triggers, covers different things, and you're going to be aware of that you're going to have a little bit of a different plan and program throughout your West Coast facilities. It also requires a safety committee. If you have 11 or more employees on the same shift at the same location, and there are different safety committee requirements depending on the makeup and number of employees. And similar to Cal OSHA, it has an accident prevention program. So it's similar to California's IIPP, where every employer is required to have that written program and to address hazards in the workplace through that program. And with that, I'll kick it over to Megan to bring us home with Oregon.
Yeah, I want to be mindful of the time, so don't want to spend too much time on this, but Oregon is a great excuse to circle back on something Valerie mentioned in the beginning, which is the variety we see in the penalty structure. And Oregon offers this example of a state that was historically on the lower end of the spectrum in terms of penalties and has now become one of the states with the highest penalties under certain circumstances, particularly where there is an employee fatality. They have a penalty structure that can greatly exceed certainly what Oregon had previous to this change, which took effect earlier this year, but is also much higher than even the federal penalties. So for citations that are classified as a willful or repeat, and they're in a circumstance where the accident caused or contributed to an employee fatality, there's a minimum penalty of $50,000 with a maximum of $250,000. And this is compared with the federal penalty max of $156,000. So it's pretty significant change for Oregon and across the nation. And then kind of one classification, or at least a step below the willful or repeat for serious violations involving an employee fatality, the range is $20,000 to $50,000. And just to give you a sense of how much the Oregon penalties have increased, their prior penalty range was about $3,700 to about $13,000. And the federal penalty max is around $15,000. Some of the other classification levels had no minimum penalty at all in Oregon and now have a corresponding penalty range that's obviously lower than the higher classifications, but does give you some insight into how some states have responded to the pressure to increase penalties and have more of a deterrent impact on employers' perceived violations of the regulations. With that, I will launch right into California. I'll just kind of give some high level differences that we see in this state. It can sometimes trip up employers who are not used to operating in California or are more used to other state plan programs or federal OSHA. The one that has been mentioned a few times is the Injury and Illness Prevention Program, which is the #1 most frequently cited standard in California. So this is where a lot of kind of general violations are cited under the IIPP citation, whether or not there's an injury involved. If there's kind of a perceived deficiency in the safety program, this is what the division will turn to cite. California also has a number of other unique regulations, and just to highlight a few, heat is a big deal in California. There is an existing outdoor heat regulation. The indoor heat regulation is going through rulemaking now. Most recent updated draft was issued last Friday, and the division has this as a very, very high priority issue. They have a special emphasis program addressing both outdoor and indoor heat. And the agency has seen a real increase in complaints and investigations stemming from indoor heat illness as that rule has been working through rulemaking. Lest we forget that we have moved to a different stage with COVID-19. California has a non-emergency rule that remains on the books with requirements through 2026. And so we can't forget about COVID here. And we know that the agency is working on an infectious disease regulation that would apply to general industry that would kind of be, and the intention there would be to replace the specific COVID regulation with a more generic regulation that could apply for whatever the next thing is that would be appropriate to address that, so they wouldn't have to go through the same emergency rulemaking process that they had to go through with COVID. There's also been a mention of reporting requirements differing throughout state plan states. California is one that has a number of significant differences, and one in particular has an 8-hour reporting rule. And there are some stricter requirements for California as well in that reporting requirement. Procedurally, sometimes we have people concerned about not completing their informal conference before they file an appeal. But in California, you can simply file your appeal and then you continue to have a right to have an informal conference after filing the appeal, even up until hearing. That kind of informal settlement conference process of back and forth between the employer and the agency happens in a pretty fluid manner throughout the life of an appeal. And then another thing that has a huge impact on the California cases is what's going on with the agency in terms of staffing. We've seen, if you follow the agency closely, we've seen really significant vacancy rates, and so that just means that folks are really overloaded with their cases, and the Cal OSHA cases tend to continue on for quite some time. They may sit for a period of months waiting for availability of a district manager or waiting for a settlement proposal to kind of work up the chain of command, but they're still at a vacancy rate of about 37%. So they're still putting a lot of effort into hiring and doing what they can to increase their ranks and their availability to deal with their docket. Just another note is kind of a West Coast, to give more of a West Coast flavor, is that the current Cal OSHA chief was formerly with Washington DOSH. So we see some of the kind of tools and things that he implemented in Washington making their way into California. And then I'll pass it back to Rachel so we can get some highlights on some best practices for employers working in multiple states.
Thanks, Megan. And as Megan mentioned about some of the unique rulemaking that's happening in California right now, we do have 2 blog posts up right now on the Cal OSHA blog that gets into what all of the rulemaking that is happening in California. If you're interested in that, please go check that out. Best practices. So these are themes that hopefully you have seen through our presentation today, things that you're going to want to be aware of for each state plan that you have facilities. Know your industry's top violation rules in that state. Megan mentioned the IIPP in California. I mentioned out in Washington, you have the accident prevention program. Those are the top ones out here in the West in those state plans, but every state plan is going to have their top violations, and those are going to be the major emphasis areas and enforcement areas for your state plan. So always a good practice to be aware of those. How to respond to an incident or serious injury or illness. Every state plan is going to have likely potentially unique reporting requirements. So don't wait until you have a potentially serious injury or illness to know what those requirements are and to scramble to figure out whether or not you need to report it, what's the time frame, what's the trigger. Get in front of those ahead of time. That's also something that one of your CMC attorneys can help you with to get ahead of and to let you know what those requirements are. Know what to do when OSHA shows up. A lot of my colleagues on today's presentation went into some really great detail about what to expect in terms of employee interviews and other procedural things like that happen in an inspection. And those are really the things that nuances you're going to want to be aware of, because those are the things that can help you really avoid citations and to have your folks that are on the ground going through the investigation process be educated on. And then, of course, know what to do when you get a citation. Each state plan has its own unique way of dealing with appeals, of dealing with notice of contest and formal conferences. So you're going to want to know how to best navigate that, and we can certainly help you through that as well. And with that, I'll send it back to Megan to update us on what is coming for webinars.
Thanks, Rachel. So for those of you who are familiar with our webinar series, great. In case you're not or wondering what's coming up next, this is our 2023 OSHA webinar series. We have a few more to round out the year. And then we also have a M-Show webinar series that we have as well for mining and tunneling, and we have the webinar series run by our MSHA guru as well. And then as Rachel mentioned, we keep our blogs updated with happenings. We have our OSHA defense report, which will cover all of our OSHA matters. Our California OSHA defense report will be obviously specific to what's going on in California. And then we have our MSHA defense report, as well as our employer defense report. In particular, when there are fun crossover issues between our employment practice and our OSHA practice, you may see articles crossover from our employer defense report to our OSHA defense report. And we wanted to provide you, and we know that these slides will be provided to you as well, but we have all of our contact information included in the slides. If you have any additional questions that you didn't get answered, or you want to reach out to us for one question or another, want more information about our record keeping, reporting masterclass, or any other questions that we've covered today, feel free to reach out. And we want to thank you all for taking the time to join us today. Appreciate your time and your participation. It was a great discussion.